Welcome back to my channel NDS Shorthand. Please like, share and don't forget to subscribe the channel. 5 seconds to go. Start. This appeal has been prepared by the state of Uttar Pradesh, the collector Balia and the land acquisition officer Balia against the judgment dated 25/9/1973 in miscellaneous reference number 3 of 1971 under section 18 of the Land Acquisition Act. Some land belonging to the claimant respondent 1 was acquired under the Land Acquisition Act, hereinafter referred to as the Act. The relevant notification under Section 4 of the issued on 4/11/1965. The notification under Section 6 was issued on 1/12/1965 and possession taken on 10/10/1966. Being dissatisfied with the amount of compensation awarded by the land acquisition officer, claimant respondent prayed for a reference being made to the district judge, and reference number 3 of 1971 mentioned above was made. Reliance before the district judge was placed on behalf of the claimant respondent on certain sale deeds as exemplars. The district judge was of the view that the sale deed dated 3/8/1965 executed by Badrilal in favor of Srimati Sujan Kumar in respect of 10 acres of land for a sum of rupees 4,500 was the best exemplar, inasmuch as it was executed a few months before the notification under Section 4 of the Land Acquisition Act, and the land sold by it was barely 1 furlong from the land acquired and was of the same nature as the land acquired. Relying on the statement of Bhagavati Datta Tiwari, PW4, who stated that the value of land at the time of its acquisition was rupees 1,000 per katha, the district judge came to the conclusion that the proper compensation to be awarded in respect of the land of the claimant respondent would be at a rate of rupees 30,770 per acre. This he did not in view of the fact that the sale deed dated 3/8/1965, which was found by him to be the best exemplar, was in respect of a small area, whereas the land acquired under the notification under Section 4 referred to above was more than 20 acres in area, calculated at the rate on which the land which was the subject matter of sale deed dated 3/8/1965 was sold. The amount of compensation comes to the rupees 45,000 per acre. If a deduction to the extent of 1/3 is made, as observed by the Supreme Court in the case of Srimati Kaushalya Devi (AIR 1984 SC 892) Supra, the amount of compensation comes to rupees 30,000 per acre. As seen above, the district judge has awarded compensation at the rate of rupees 30,770 per acre, and on the evidence on record, we are of opinion that no case has been made out for reducing the amount of compensation awarded by the district judge, inasmuch as the reduction to be made is not necessarily to be to the extent of 1/3. It may vary between 1/4 and 1/3, even according to the case of Srimati Kaushalya Devi Supra.